Paging Aitken Robertson to courtroom number 2. The jury is back with a verdict. Members of the jury, how do you find the accused? Guilty or not guilty?
Not guilty on all accounts, Your Honor.
Hi everyone. Today I've got counsel Taryn Paul Dhaliwal with me on the Legally Speaking Aitken Robertson YouTube channel, and we are here to discuss an important step in the criminal process, the judicial pretrial. So Taryn, what is a judicial pretrial, or as we know it, a JPT?
So a JPT, or judicial pretrial, is essentially when the Crown Attorney, the defense lawyer, and the judge would sit down and discuss the criminal case.
And when is this? When in the process can client expect for him to be informed that a JPT will be held?
So typically a JPT is held after a Crown pretrial has already been conducted. Crown pretrial is essentially the first step in the negotiation process with the Crown Attorney. A JPT is not always required. Depending on the circumstances of the case, a JPT might be required, but it's not always required depending on the case. A JPT would happen for a few different purposes. Number one, a JPT can happen to get the judge's insight and input on a particular resolution or trial. The judge at a judicial pretrial is not going to be the same judge if the matter does proceed to a trial. The judge at the judicial pretrial would hear the Crown's analysis on the case and also the defense lawyer's analysis on the case and provide input. It's important to note as well that the judge at the judicial pretrial doesn't have the ability to decide a case. Ultimately, the Crown Attorney is the one responsible for prosecuting the case and has the discretion in terms of how they want to proceed. But the judge could give his or her thoughts on what they would do if they were the Crown Attorney or if they were the defense lawyer, and also give their thoughts on potential resolution.
And what about if there's any pre-trial applications? Is this the time and place to bring that up as well?
Absolutely. So at the judicial pretrial, the defense lawyer has to be in a position to make binding decisions on behalf of the accused. For example, if the defense wants to bring a pretrial application in a sexual assault case, you would have to notify the judge of that. If the defense wants to bring a charter application to litigate at trial, the defense would have to inform the judge at the JPT of that as well. All of these considerations go into the trial estimate and timing. These are all very important steps that are discussed at the JPT.
Can a judge provide approval for a joint submission if the Crown and the defense had prior discussions? There's a joint submission. What's your thoughts on that and getting the judge's approval?
Yeah, so ultimately, when there is a joint proposal, meaning the defense and Crown Attorney are both putting forth a position for the judge to consider, it's very unlikely for a judge to deny that. But the judge at the JPT will give his or her thoughts in terms of what their inclination is. So if they're inclined to grant the proposal, they'll let you know. And if not, they'll also give their thoughts on why this proposal is not something that would be in the cards, or, for example, why it would be contrary to the administration of justice to propose that or to grant the proposal that's being put forth by the prosecution and defense.
Everyone that's present at the judicial pretrial, does the client need to be there? Who's everyone that's actually involved?
So typically it's the judge, the Crown Attorney, and the defense lawyer. The judicial pretrial can also be held by the accused person themselves. It's called a self-rep JPT. in a situation where the client has not fully retained the lawyer, that's a situation where the client would have to appear at the JPT, his or herself. Otherwise, it would be the defense, Crown Attorney, and the judge.
And no other witnesses.
That's correct.
Thank you so much, Taryn, for joining us today and to discuss the importance of the judicial pretrial in the criminal process. If anyone would like to get in touch with you, how do they go about that?
The best way is to reach out to our website at fighttocharges.com.
Thank you so much, Taryn. And thank you for everyone else for joining us on the Aitken Robertson YouTube channel. Don't forget to like, subscribe, hit the notification bell so you don't ever miss another video. And until next time, stay informed, stay engaged, and take care. Thank you for tuning in to Legally Speaking, proudly brought to you by Aitken Robertson Criminal Defence. We represent clients facing criminal charges all over Ontario, providing you with legal support and dedicated advocacy. If you enjoyed this episode and want to see more content, please like and subscribe to our channel. For more information, visit our website. We also offer free books on various types of criminal charges, which you can request on our website or by using the QR codes on your screen now. For legal assistance, call us today or visit our website to request a meeting with one of our experienced lawyers or licensed paralegals. Thank you for watching, and we'll see you next time on Legally Speaking.